did the White House give you to prepare for today's hearing?
Senator, there were a number of meetings with the White House counsel's office.
Did they give you any written materials to read?
There were some written materials.
Tell me, what were those?
There were materials that were already in the record, questions and answers from prior hearings.
So they gave you a list of questions and answers from prior hearings?
An overview, I would say.
Yeah. How many?
What's up, everyone? Today we're diving deep into a fascinating Senate Judiciary Committee hearing where Senator Kennedy put judicial nominees through their paces. If you're into law, politics, or just enjoy watching skilled questioning in action, you're in for a treat. Before we get started, hit that subscribe button to stay updated on more political analysis like this. Let's kick things off with Senator Kennedy's first major move. He started by questioning Judge Gaston about a controversial 2008 writing regarding sex offenders and child safety zones. Now, this is classic Kennedy style, beginning with a quote that immediately puts the nominee in the hot seat. What's particularly interesting is how he used this to set the tone for the entire hearing. Moving on to what I like to call the legal knowledge test. Kennedy masterfully shifted gears to probe the nominee's expertise on fundamental legal concepts. Ms. Al-Madani had to explain qualified immunity, while Judge Hunt broke down the standards for summary judgment. This wasn't just random questioning. Kennedy was systematically testing their practical legal knowledge. Now here's where it gets really interesting. The questioning about New York Times v. Sullivan and precedent-setting cases revealed something crucial about these nominees. One judge even admitted to limited experience with a landmark First Amendment case. This is the kind of moment that can make or break a nomination. Hey, if you're finding this breakdown helpful, make sure to hit that subscribe button. I break down important political moments like this every week, and trust me, you don't want to miss what's coming next. The most explosive part came at the end. Kennedy's questioning about White House preparation revealed that nominees received between 10 to 50 previous hearing questions and answers. Even more interesting, they specifically studied Kennedy's past questioning styles. This shows just how seriously they took his reputation for tough questioning.
I'm going to quote, children are not safer because registered sex offenders are prohibited from residing near schools, parks, daycare centers, and other places where children tend to gather. End quote. Did you write that?
I co-wrote that article, yes, sir.
Okay. When you wrote it, did you believe it?
I did.
Okay. All right, let's start back down on this end. Ms. Al-Madani, tell me about this doctrine of qualified immunity that we're discussing here in Congress and in the newspapers.
Thank you, Senator Kennedy. Qualified immunity applies in 1983 cases as well as Bivens actions to law enforcement officers.
Right.
Unless there is a clearly established constitutional violation, they are subject to qualified immunity. They are immune.
Okay, thank you for that. Let's go to Judge Hunt. Judge, what is the standard? I'm sorry, I keep bumping my mic. What's the standard for granting a motion for summary judgment in federal court?
Thank you for the question, Senator. Summary judgment motions in federal court are evaluated under Federal Rule of Civil Procedure 56. The question is whether there is a genuine issue of material fact that will require a trial. The moving party has the burden of proof of establishing that there is no genuine issue of material fact and that judgment should be granted as a matter of law. If the moving party does not meet that burden, then summary judgment is denied and the case goes forward to trial.
Okay. So basically it's just, are the facts in dispute and is law in your favor?
That's probably a shorthand for it, but really it's, are there material facts in dispute? Because in my experience, there are often factual disputes, but the question is whether they are material to the resolution of the issue.
Otherwise, you wouldn't be in court.
Exactly.
Judge Hugh, tell me about New York Times v. Sullivan.
I believe that was a First Amendment case, Your Honor. I'm sorry, Senator, about free speech. But in my 5 years of being a judge and 25 years of practice, I haven't had to actually apply New York Times v. Sullivan.
Okay. Judge, well, I talked to Judge Yassen. Judge Cummings?
Good afternoon.
Good afternoon to you, sir. Tell me the rule that the United States Supreme Court follows in deciding whether to overturn precedent.
Thank you for that question, Senator.
You're welcome.
In deciding to overturn precedent, the court looks at a number of factors, including the soundness of the reasoning of the decision in question, the workability of the rule that it establishes in terms of how it is applied, developments that have taken place since the decision was issued, and they also look at reliance that parties or litigants have placed upon that decision in question.
Okay. Let me ask you, well, I'll start back here again. What did the White House give you to prepare for today's hearing?
Senator, there were a number of meetings with the White House counsel's office.
Did they give you any written materials to read?
There were some written materials.
Tell me, what were those?
There were materials that were already in the record, questions and answers from prior hearings.
So they gave you a list of questions and answers from prior hearings?
An overview, I would say.
Yeah. How many questions and answers did they give you?
I'm not sure, Senator. Sitting here, I'm not sure exactly how many questions.
Was it more than 10?
Yes.
More than 50?
I don't believe so.
Okay. And whose questions were they?
They were Senator's questions.
Which ones?
There were some of your questions, Senator.
Were there?
But I also...
So there you have it, a masterclass in Senate questioning that revealed both the preparedness and potential weaknesses of these judicial nominees. Kennedy's methodical approach, moving from specific writings to legal knowledge to preparation methods, demonstrated why these hearings are crucial for our judicial system. Don't forget to like this video if you found this analysis helpful, and hit that subscribe button for more deep dives into political proceedings. Drop your thoughts in the comments below. What do you think about Kennedy's questioning style? Until next time, this is Channel Name signing off. Outro. Thanks for watching. Click the bell icon to get notified about new uploads, and I'll see you in the next video.